Okay, so I just wanted to come back to Encino Motor Cars because this is a case where the court wound up saying that the agency's interpretation of the statute was not entitled to deference because there was a procedural flaw in the regulation interpreting the statute. And so it was like the regulation really never existed in the first place. And so the court had to interpret it. And so they remanded for the lower court to do that in the first instance, but I thought it was a useful exercise to spend a few minutes looking at it. So I've pulled up the text of the statute here. Just a reminder, this is a listing in 29 USC section 213 of categories of employees who are exempt from the overtime rules or from some specific overtime rules. There's actually more than one list in this section. And so this is the one in subsection B, which is, section 207 doesn't apply to these people, but all of that complication doesn't matter for our purposes. And subsection B is this long list of different job titles and classes and categories and stuff like that. And I have put a few of them in here as just kind of a sample of the kinds of things that Congress has said are exempt here. There's like 30 some odd of these things. And so, obviously this is only some of them. But so we see in subsection 1 that any employee with respect to whom the Secretary of Transportation has the power under some other statute to set maximum hours. So that might apply to, for example, airline pilots, where the Department of Transportation can set specific regs about how many hours they're allowed to work that are different from the normal overtime rules. And so they're exempt from the normal overtime rules because the Secretary of Transportation is doing their own thing. Subsection 2 is sort of similar. It's about railways under the Railway Labor Act. And so if they are regulated by other pieces of the government, and so they're not subject to the normal Department of Labor regs. And then there are some that are not like this other regulator or something. They're like anyone who works as a buyer of poultry, eggs, cream, or milk, or any employee who is a seaman, or any employee employed by an establishment which is a motion picture theater. There's some random ones like that. There's one for like news anchors at TV stations within towns of less than 100,000 people. I have no idea why. And then the one that's relevant for our lives is 10A, where it talks about any salesman, partsman, or mechanic primarily engaged in selling or servicing automobiles, trucks, or farm implements if he is employed by a non-manufacturing establishment primarily engaged in the business of selling. So if you work for a car dealership.
Zoom.
Yeah, go ahead, sorry.
We were just having some tech issues in the classroom. Everything's fine.
Okay. Did you miss anything? Do I need to go back?
No, you're good.
Okay. So we were talking with Mr. Baldwin, Mr. Jordan, Ms. Osborne, and Ms. Tolman. How would you interpret this? So if we wanted to use our 4 standard tools, if we wanted to start with text and then legislative history and purpose and canons of construction, if there are any that are relevant, what do we think about the text? Does someone who is a service advisor fall within this subsection? What do you think?
I think when I was reading it and trying to figure out how they wouldn't fit into it, I kind of thought of it as, salesmen sell cars, partsmen get the parts, and the mechanic actually work on the cars. And so to me, thinking about it, service advisors didn't really do any of that. They kind of interact with the customers. They sell them parts, but not cars.
Mhm.
And so I guess you could kind of see how they might think that they don't fit into that.
Mm-hmm. But you sound skeptical.
I think that they're probably more involved than just working with the customers and just selling them parts. And I think that maybe because they don't sell the cars, they're still actively involved in work in like helping the customers with them. Maybe they're considered that, but I could see how there's like kind of an issue.
Mm-hmm.
Yeah, I was thinking something a little similar, whereas
I was sort of thinking that somebody who has the title of service advisor might still, just by the virtue of like what their job entails or what their dealership does, primarily do selling or servicing automobiles, trucks, or farm implements. And so I guess I think they could qualify for this exemption if they primarily do that, even though their title would be service advisor, I guess.
So, but how are they doing that? Like, what's your theory on why they're doing that? Think that,
Because
like, they
maybe,
have the wrong title?
yeah, something akin to that, I guess, that their title is service advisor, but maybe their dealership is short staffed for partsmen. So what they primarily do is like picking up the pieces for that department or something.
Mm-hmm. Anyone here ever bought a new car and in the process of that talked at all to the service department? Yeah, I mean, so it's probably not the norm, right? But it does occasionally happen. Like when I've bought I guess two new cars in my life. And one of them I asked, I had a question about something related to like how the infotainment map system worked. And the sales guy didn't know. And so he like brought in a service advisor to talk to me about it. And so he was playing a role in the sales process, but it was a relatively minor part of his job, right? What about the grammar here? So if we wanted to break it down grammatically, we've got this list of 3 job titles: salesman, partsman, or mechanic. Does primarily engaged in selling or servicing automobiles, trucks, or farm implements modify all 3 of those, or does it only modify mechanic?
I think it would modify all 3 of those. And in reading this, I took a more broad interpretation, I guess. I don't think it would be possible for the people drafting this to spell out every position that they intended to include. So I think this is intended to be broad and encompass service advisors as well.
Yeah, it certainly seems likely that if we asked Congress when they were drafting this, hey, do you want to include service advisors? They're these people who work at car dealerships who sell the services. You're including the people who sell the cars and the people who perform the services. Do you also want to include the people who sell the services? And probably they would, right? But they probably didn't realize those people exist, I guess. So that seems like the most likely legislative intent, although we don't really know, right? Why did you think that primarily engaged in selling or servicing those things modifies all 3 of those nouns? Because normally if we have this modifying phrase, we would assume that it only modifies the last noun, right?
Yeah, looking back at it, I guess it is kind of unclear. That's how I first read it, but now that you mention it, I guess there's really no way to tell whether it only is intended to modify mechanic.
Well, I think maybe it wouldn't make sense if it was only intended to apply to mechanic, because when you think of or when I think of a mechanic, at least, I don't think of that as someone who primarily engages is in selling automobiles. Again, that could be like, I guess, just like a mistitling thing, but it seems logical that it would apply to all 3, I guess, just
Yeah.
based.
Sorry, go ahead.
Oh, that was the end. That was all I had to say.
I mean, so normally, like, if we had a list that was like, attorneys, medical doctors, and people who have been determined by a board to be mature, right? If it was like a list of people who are entitled to, some kind of rights to do something, I don't know. We would normally think that the people who have been determined to be sufficiently mature by this board or whatever would only apply people. It would be kind of other, right? And so normally we would think that a big phrase would only modify the last noun on the list, unless it was like separated off by a comma. If it was like salesmen, partsmen, or mechanics, comma, who are primarily engaged in blah, 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 then we would assume that grammatically it modifies all 3. But here it doesn't really make sense if we follow that normal rule, because mechanics don't primarily sell. And if we thought that primarily engaged in selling or servicing automobiles, trucks, or farm implements only modified mechanic, then this exemption would apply to every salesperson, not just sellers of cars, right? And so it seems like a salesperson or a partsman or a mechanic must be primarily engaged in selling or servicing automobiles to be covered. Does that include service advisors?
I think the argument exists, right, that you have a salesman who's primarily engaged in servicing automobiles.
Yeah, I guess that would be
you
the
can
argument that they're
extend-
covered, right?
Yeah.
Because they are a salesperson, they're in the greater ecosystem of people who are doing servicing. So maybe they are covered, but they're not selling the cars and they're not doing the services themselves. They're selling the services. So you can come up with an argument that they wouldn't be covered, right? On the other hand, are partsmen selling cars or servicing cars?
All right. They're kind of like the intermediary who just acquires the parts and then gets them to the servicing people.
Yeah, and sells parts and orders parts and maintains the list of parts, right? So they're not really doing either of those things either, and yet they are clearly covered here, right? Unless we think that that is surplusage, which this is bringing in a whole bunch of arguments that really are disguised versions of canons of construction. The surplusage canon says we don't interpret it to have text that has no purpose. You know, the canon of we avoid an unreasonable interpretation would say that's why we say primarily engaged in selling or servicing applies to all three of those things, right? And so we're using these sort of rules of thumb that are kind of grammatical rules of thumb or interpretive rules of thumb that are really just canons of construction. But so we can come up with an argument that they would be covered, and we can come up with an argument that they wouldn't be. That seems like a vote in favor of Chevron deference if the regulation was, you know, correctly adopted. Which, you know, Justice Thomas had argued that the text reveals that service advisors are salesmen primarily engaged in selling of services. Accordingly, they should be covered. Not clear to me that it unambiguously meets that, right? Although maybe he's saying that's just the best interpretation if they have to interpret it in the first instance, rather than an interpretation that would be unambiguous under Chevron step 1. Do we know anything about legislative history here? Or maybe more promisingly, do we know anything about like the purpose of the statute? I mean, go ahead.
I was just going to say, I think the only legislative history that's in the case is that this current reading is it's like the second rule that Congress promulgated, where it split up the exemption from one sentence into 2 sentences.
Mm-hmm.
But I don't see that helping. Just
yeah, it doesn't really tell us much, right?
Yeah.
We could try to come up with some kind of purpose for this. Maybe car sales people are exempt from overtime pay because they're not paid hourly. They're more paid like their pay is clumpy, right? Like if you sell a car that makes a bunch of money, you get a big paycheck for that car. And then if you go a week without selling any cars, you get a tiny paycheck, right? And so it seems like it's not really compatible with like hourly overtime pay in a sense, right? It's sort of like realtors are similar. Realtors get a percentage of the sale of a house. They don't get hourly pay. And so, you know, if they put in an extra hour to make a sale, it's not like they get another hour of like overtime pay for that. Instead, they just get their commission. I don't know about mechanics though. Anyone know how mechanics are paid?
Salary/hourly.
Salary/hourly. So they're not paid like on a per, they don't get paid like, $750 for a transmission job and like $38 for an oil change or something like that.
My dad is a marine mechanic, got paid hourly.
Yeah. Okay. So that doesn't really tell us much. I mean, if we went through the list of exemptions, some of them seem like they are areas where there's another regulator who's in charge instead of the Department of Labor, like the ones about, railways and air carriers and stuff. But some of them are things like, an outside buyer of poultry and eggs, or anyone who works at a movie theater, or anyone who is engaged in the processing of maple sap into sugar or syrup, right? So some of it just seems like random, or, I have no idea why.
I have a question.
Yeah.
Would it be based on like just the kind of job then, as far as like who gets excluded and who doesn't? Because like another big part of it too would be like home workers and stuff like that, people that work on farms and people that work in the house. So
yeah, there are several that fit that description, right? So there's like any employee who is employed with his spouse by a nonprofit educational institution to serve as the parents of children who are orphans or reside at the children. There's one about like, like domestic service employees who reside in the household where they're employed. So there are several that fit that, and those might be hard to think about in terms of hourly pay. I don't know how maple processors are paid, or what their hours are like, or what they do, right? Like, I don't know if the tree farm is providing them housing like we saw in the herders case a while ago or something like that. I have no idea if something like that is the case. There's also like anyone operating taxi cabs is exempt. But a lot of them seem like the kinds of things where there's not kind of a standard hourly pay structure. There's a criminal investigator exemption, it says criminal investigator who is paid availability pay, which I take it is something like, a retainer for being available to do investigations or something. So some of it seems like things that are not really hourly, but like movie theaters, I have no idea. Movie theaters, my guess is something about like, they assume that they're mostly 16-year-old kids or something. I don't know. So then the takeaway then is that like, we have an opinion that finds a regulation to fail hard look analysis for procedural reasons, not for substantive reasons. That they didn't provide the proper explanation of why they had done a change, which is something that it seems like is not really what Chevron Step 2 is about, right? Like, because Chevron Step 2 seems like it was intended to be more about the substantive reasonableness of the interpretation adopted by the agency. And so a couple ways to read this. One is that maybe if the regulation wasn't correctly adopted procedurally, then it's just void. Like under 706, there is no regulation. And then we have to fall back on the statute without a regulation. Another way to view it is that some people think that this means that Chevron Step 2 includes both substantive unreasonableness and also procedural unreasonableness. That if an agency adopts an interpretation in a way that is, procedurally unfair, then it doesn't get deference. And those lead to the same outcome. So it's not clear, what the implications of one versus the other are, but that's two different ways to think about this case. Questions about that before we turn to Chevron's domain or Chevron Step 0? Okay, thank you, Mr. Baldwin, Mr. Jordan, Ms. Osborne, and Ms. Tolman. And I'm going to stop my screen share. Okay, so that takes us to one case out of two in the book, really, about whether we should apply Chevron at all in a particular case. or whether we should do something different, like interpret the statute de novo or apply Skidmore deference or something less deferential than Chevron. And this is something that is sometimes called Chevron step 0, meaning the thing you do before you get to Chevron step 1, decide whether to do Chevron or not. That's a term that the court has never used. But it's a nice way to think about it. Chevron's domain is sort of saying the same thing. And so after Chevron was decided, one interpretation was that it basically threw out Skidmore and old cases like that that did not grant deference. That before Chevron, we had the court kind of deciding on a case-by-case basis, are we going to defer to the agency here, or are we going to do our own interpretation? And so that's cases that we read like Skidmore and like the one about the definition of newsboys and whether they were employees or not. And that's a plausible interpretation because the pre-Chevron state of the world seemed to be that kind of case-by-case decision. And Chevron seemed like it had replaced that with a kind of blanket presumption. But then in 2000, in a case called Christensen versus Harris County, the court applied Skidmore again and cited Skidmore and didn't apply Chevron deference. And then in Meade a year later, the court did so again and made clear that that wasn't just a fluke. So for Meade, we've got Mr. Carroll, Mr. Downing, Ms. Gillis, and Ms. Murphy. How are you? Are you around?
Yep, I'm here.
Yep, I'm here.
Here.
Hello. So what's going on in this case? What's the agency? What's the statute? What are they trying to do?
So the agency is the U.S. Customs Service under the Department of Treasury, which decides duties on imports. And the act is the harmonized tariff schedule of the U.S., which customs are taxed under. And it provides that customs shall, under rules and regulations prescribed by the Secretary of Treasury, fix the classification and rate for duty for certain merchandise. And the Secretary of Treasury provides for this by issuing ruling letters, which are binding on customs personnel with respect to certain goods and certain people until or unless they are revoked or modified.
And so what's the customs letter ruling in this case about?
It was about planners and whether or not they would be, or whether or not planners would have a 4% tariff applied to them. Because there were two categories. One of them included diaries, notebooks, address books, memo pads, letter pads, and similar articles. And then there was a second category, just including other items. And prior to this ruling letter, planners had fallen into the other items category, so they didn't have that 4% tariff applied.
Yeah, so we've got like, so just to sort of like make this super clear so everyone is sort of on the same page, right? We've got statutes that set tariffs in ways that are broad and kind of vague because like you can't have a statute that covers like every single product, right? And so it lists these categories of products. And sometimes there's a little bit of overlap between the categories. Sometimes there's categories that, you know, or items that don't seem like they clearly fit within one category. And so Meade for years had been importing day planners and not paying customs duties on them, not paying tariffs under an interpretation that they fit into one category. And then suddenly they got this ruling saying, no, now these are diaries. And so you have to pay a 4% tariff because that's a different category. So what's the deal with these letter rulings? Like, where do they come from? How do they get created? Who decides what to do?
I think at like each port where the product is coming in, it gets evaluated by like one of the tariff employees that are there, implies a tariff ruling, and then they decide like kind of on the spot whether or not where it falls in the tariff schedule. And then that letter comes out and it's only binding to that person and that product specifically. Like they openly say that no one else should rely on it. And then they do it every time. So they put out like 10,000 to 15,000 letters a year.
Has anyone ever like run into this, like when coming into the country, like having to deal with the tariff customs people?
Yes, they ask if you bought any like souvenirs 100 times, and they make you show the list 100 times, and it's very meticulous.
Yeah, so if you're entering the United States, you'll be asked like, did you buy anything? What did you buy? They'll be more or less meticulous depending, right? Like sometimes they'll just wave you through. Sometimes they'll ask you a whole bunch of questions. It sort of depends on their mood and like how busy they are and stuff. Like one time I was coming back to the US and I had bought a laptop in another country, and that was over the limit on the amount you're allowed to bring in at the time. I think now it wouldn't be, but and they like sent me to this sort of secondary area where like this guy brought out this giant like phone book looking thing, like flipping through looking to find out what the tariff was on it. And he eventually decided that there was like a 2% tariff or something like that. And so I had to go to a little window and pay like a tax of, I don't know, $50 or something to bring in this laptop. But it was very much this like sort of, you could totally imagine like the kind of thing where no one had noticed and no one would care, and you'd just enter and they would have waved you through, right? But like the time I entered, they happened to be like looking more closely at the little form you filled out where I said I bought a laptop, and they were like, oh, you have to go over there. And it's sort of like that writ large, right? Like if you're a company importing like 10,000 day planners to send to a warehouse and then send out to a bunch of stores, there are 46 of these ports of entry around the country where customs has an office, and someone shows up with like a load of 10,000 day planners. Someone does the same thing. They kind of decide what category this is in, and they issue a ruling letter. And the ruling letter is like, how is it a rule? Is it an adjudication? How binding is it? What is it? What is its like formality? What is its like, what kind of thing is it? It's weird, right?
I think that's what this whole case is about, is the fact that the court holds that it like doesn't have the force of law. It seems almost, it doesn't have any formal procedures to go through. It just, someone looks at it, they put out a very brief letter just stating this is what it's subject to or it isn't subject to. And in the letter, they say that no one but that party is bound by this ruling letter. And then they just do that over and over and over again. And so the whole weirdness of what is this ruling letter is what this whole case hinged on. And I think the court found that it didn't have the rule of law, and it was just this kind of like opinion of this one custom officer.
Yeah, that's the weird thing, right? Like it says this is not precedent for anyone but you, anyone but the importer we're giving this letter to, but it can be precedential for future importation by that one party. Like they can say, here's our letter saying they've concluded that this is a thing, right? And the customs people will follow that in the future unless they've like revoked it or changed something, right? So it's precedential unless it's modified or revoked, which is more binding than like a interpretive rule or a policy statement, but it's less binding than like a notice and comment rule, right? And so, it's in this kind of weird, like middle ground. And so Mead here says, well, we got this thing, we don't like it. We went to the Court of International Trade, and the Court of International Trade did what?
Did they reject that the customs argument that Chevron should be applied? And I think said that it wasn't, they gave them no deference, and then I think said that the change was not okay.
So the Federal Circuit did that, right? Which is the Federal Court of Appeals. It's one of the two located in DC. It's the one like a block from the White House. It's the one that handles patent cases most of the time, but it also gets international trade cases and like government employee labor appeals. And there's a bunch of like random categories of cases that go to this court. And one of them is appeals from the Court of International Trade, which is a non-Article 3 court. It's what's called an Article 1 court, meaning it's really kind of the executive branch. It's a piece of the executive branch. Its judges do not have life tenure, but it's kind of a court. And that court applied Chevron deference and said, well, this is a decision of the agency. And it's the agency interpreting the statute that is administered by that agency. So we should apply Chevron deference. Why not? And the Federal Circuit said, no, these don't get Chevron deference. So that's kind of the question here. This court says no. Why? What's the reasoning here?
It looks like what they're saying is that Congress didn't intend in this statute to allow these rulings to have the force of law that happen thousands of times a year.
Yeah, that if we think back to Chevron itself, right? Chevron says when Congress is vague, that is an explicit delegation to the agency to fill in the gaps, right? But Congress here, the court says, didn't intend that. And so like the closest we have to a rule here is probably this paragraph that starts at the bottom of 854 and finishes at the top of 855, where the court says, we hold that administrative implementation of a particular statutory provision qualifies for Chevron deference when it appears that Congress delegated authority to the agency generally to make rules carrying the force of law, and that the agency interpretation claiming deference was promulgated in the exercise of that authority. And then they say that we can show the intent to delegate in a variety of ways, like the power to engage in adjudication or notice and comment rulemaking or some other indication of comparable intent. And here that fails to qualify, although it might still get deference under Skidmore. So the rule that comes out of this case then is that we need to do some kind of case by case or statute by statute analysis to decide if a particular statute gets Chevron deference or not. And so how do we do that analysis? How do we know if Congress intended to delegate that authority in a particular case?
One of the things that they mention is the express or implicit authorization in form of rulemaking or formal adjudication, and if the agency actually employed those measures. But then they also note that a procedural formality like that is not necessarily a condition for Chevron deference.
So why would a procedural formality like that help us? Like, why would that be a useful indicator?
Because Congress is showing like its intent or express authorization for the agency to do something.
So like Congress passes a law that says, you know, we regulate the telecommunications industry in the following 87 ways, right? And one section says the FCC has the power to do notice and comment rulemaking to, you know, implement the provisions of this statute. That's sort of Congress saying explicitly, we are intending the agency to interpret our vaguenesses, right? The things that we have not filled in, the details we have not provided, we are specifically saying we want the agency to fill in those gaps. And so if they can do notice and comment rulemaking either explicitly or implicitly, that seems like an acknowledgement that Congress has been ambiguous in ways that would need to be filled in that way, right? But then you pointed out that they also say there might be some other indication. What else would be like what else would be an indication of that?
They don't necessarily say, they kind of just say some other indication of comparable intent of Congress, but they don't explain exactly what that would mean.
Mm-hmm.
But they do go into look at different factors in the case, because since they're saying that it's not pertinent that they take part in notice and comment rulemaking and they didn't hear, like that isn't the only deciding factor. They go through all of these other factors as well.
So how do we know there was no similar intent here? Like, what are the factors that tell us that here?
One factor that they bring up is that it wasn't binding to more than one party, which is something that you would see in like a rule that had the force of law over multiple parties. And they also discussed how many letters are put out each year by the customs officers, and they're like, no other agency would put out that many binding rules. So they looked at the number of 10 to 15,000 as problematic to Chevron deference. And then they also, as Sydney said, looked at the process in which the letters are created, which is not part of like any formal and informal rulemaking process.
Yeah, so we've got 47 different offices putting out tens of thousands of these things a year. They don't bind the agency as a whole. They don't purport to be kind of the considered judgment of the agency as a whole. They're just kind of like one random customs officer saying, yeah, I think these are diaries, sure. And so there's no sign really that this is an exercise of Congress delegating some power to the agency as a whole, right? It seems, if anything, it's sort of like, quick and dirty, like implementation of rules. And if there is really something that is like super ambiguous that the agency would want to resolve, can it still do that in a way that would get deference?
I think because they are an agency, they could still choose to go through the notice and rule comment process to fix a large scale and like ambiguity. So, and then that one would get deference, Chevron deference, but sorry.
Like if there was sort of a recurring issue that they didn't want the people on the ground to keep making this decision over and over, right? Or getting inconsistent results, or there's a new category of product that wasn't previously envisioned or something, right? They have the power to decide that. They just have to be a little more formal about it. So what do we think? Is this a reasonable argument or a reasonable conclusion by the court? Like, what's the argument in favor of this?
In favor of this, it's just the fact that these daily planners weren't in the statute, and that these were interpreted choices made by these agents on a day-to-day basis. And so this is way out of the authority that Congress delegated to this agency to make these kind of broad interpretations that can have serious effects on customs and trade coming in.
Yeah, maybe this is like, in the end, a reasonable read of congressional intent, right? Like, we've got a weird circumstance where we've got a whole bunch of individual actors in 47 different offices kind of doing messy, spur of the moment decision making. And it's probably a little unreasonable to think that Congress was intentionally delegating to the agency not just the power to like enforce the law and assess tariffs, but the power to make decisions that would then get deference from the court about what was going on, right? Because like if the tariff officer said these things are diaries that get a 4% tariff, and the court had to defer to that under Chevron deference, but then a different customs officer with a competitor of Meade said these things are not diaries, these things are like notebooks or planners or whatever the other category was, they get a 0% tariff, that one also gets deference from the court. Like, it would be weird if the court was deferring to these inconsistent interpretations with similarly situated people. And so it seems like it might be reasonable to think Congress didn't really intend that. Is there an argument on the other side?
I would just say it makes it really confusing. Whether or not a company can rely on, it just creates a level of unpredictability. Are we going to be under a Skidmore test, or are we going to be under a Chevron deference test when we are forced to litigate this, and that's going to make the whole difference between winning and losing or getting a 4% tariff or not.
Absolutely, right? Or maybe even a non-deferential test, maybe just Genova review, because it's not clear if we get Skidmore or not, right? And so, like, if the whole point of Chevron was, before Chevron, we had this weird, inconsistent back and forth where we were making this like difficult case-by-case decision about whether to defer or not, and we wanted to replace that with a clear presumption. Now we're backing off on that. Now we're saying, we're throwing out kind of this simple, elegant presumption and making it harder to apply. We're doing something messier and iffier that looks more like the pre-Chevron state of the world. And so that's going to make outcomes less predictable, because if you are a party thinking about like appealing this decision to court, you may not know whether you're going to get Chevron deference or not. And that might tell you, that might make it harder to know, like, do we have a good case or not? Because the distinction between like binding legislative rules that are issued pursuant to notice and comment rulemaking and non-binding rules like these tariff letters is not always a clear one. So there is a good argument on the other side. It's an argument that only persuaded one justice, which is kind of remarkable. But the court winds up sort of limiting the scope of Chevron here. And so what do we do with this classification ruling? If it's not like a notice and comment rule, what is it like? How should a court think about it?
Almost like an administrative or procedural rulemaking.
Yeah, right. We went through earlier those things that are exempt from notice and comment under Section 553. Procedural rules or rules of internal agency organization or structure or process or whatever, policy statements, interpretive rules, and then things like national security and good cause and stuff like that, right? And the court says on 858, first full paragraph at the top, in some, classification rulings are best treated like interpretations contained in policy statements, agency manuals, and enforcement guidelines, which are those things that fall under those exemptions to notice and comment. Let's say they do get Skidmore deference. So how does Skidmore deference work here? Like, what will the court do if it has to evaluate this tariff ruling?
The court will look at what the agency said based on its persuasion, not necessarily because of the authority that the agency has, like unlike Chevron, and they'll look at the overall agency expertise and experience, and then the court quotes the factors that they consider, including validity of reasoning, thoroughness of consideration, consistency, and all other persuasive factors.
So Skidmore then kind of sounds like this sliding scale where like the amount of deference the agency get will vary depending on the circumstances based on how big an expert the agency is, how much care it's taking, how consistent it is, how persuasive it is, right? Yeah, sorry, go ahead.
I was just going to say Justice Scalia says that he has a problem with that totality of the circumstances.
Yeah, not surprising. We'll get to that in a second, right? But like how, so then what's your guess on how deferential we should be here if we were applying Skidmore deference?
I think that this agency is probably like the most knowledgeable in this area. It's their entire purpose is to figure out where products fall on this tariff schedule. I think the person looked likely actively at the product, so there was like some good evidence used. So I think it might be close, but I think the court would apply Skidmore deference to this rule letter.
So we've got some factors that are pretty favorable for deference here. You know, they are very expert. They do this all the time. They have seen the products directly, right? So they have a more hands-on degree of knowledge than the court would. Any arguments that would weigh against Skidmore deference here?
That would be inconsistent. based on the prior rulings.
That sort of this represented a change, and they were, you know, previously it said 0%, now they're saying 4%. So we don't have a clear explanation for that. That would be a problem. What do we know about like how, you know, persuasive and well-reasoned or something this particular thing is?
Yeah, they weren't really giving reasoning at all. They were just making a ruling and then subjecting the exporter importer to it.
Yeah, this is not like a well-reasoned policy statement that an agency puts out that like maybe doesn't go through notice and comment, but still was written by like lawyers at the headquarters and really reviewed and given a lot of thought, where like it's published in the Code of Federal Regulation or something. This is, you know, one page from like a tariff officer in you know, Nebraska or whatever, saying like, no insult to Nebraska if you're from Nebraska, you know, congratulations, but like just some random person at one of 47 offices saying like, yeah, I find these are diaries, 4% tariff, you know, next, right? There's no real reasoning or anything like that, so that might weigh against it. And so this is why, you know, we're replacing kind of this bright line rule with kind of something that's going to be much harder in practice. Which takes us to Scalia's dissent. So Scalia is grumpy, right? What's his problem with this?
Scalia is unhappy. He thinks that they kind of revived the whole Skidmore doctrine, something he thinks that they kind of moved past already. And he thinks that this is just going to increase complexity, increase ambiguity. And I think, I forget exactly, I think he said they had basically had maybe a bright line standard before this, or it was more clear, and that this is kind of going in the face of that.
Yeah, that's that's very much his point, right? That this is really a dramatic alteration of Chevron, where before it provided this kind of bright line rule of a presumption of delegation to agencies, a presumption of authority to resolve ambiguities. And now the presumption is you don't have that authority unless we can come up with some affirmative legislative intent in favor of it. And so agencies are losing power here. Good argument, or is he being revisionist, or is he missing something?
I mean, I think his main concern is that a bunch of cases that had previously been decided where agencies had been granted that deference going forward, you know, we're going to have tons of cases where there's going to have to be tons of litigation surrounding whether or not the fact that deference should be given at all.
Yeah, like he's probably completely right about the effects of this case, right? That it will lead to a lot of uncertainty about whether to apply Chevron at all. But the argument, at least as like a historical matter, about Chevron creating this bright line rule seems a little iffy, because like the majority in Chevron itself didn't intend that, right? They thought this was like an incremental change. So he might be right as a matter of what's the best rule, but it never really had a majority of the court in favor of it. So then the bottom line is that like a slightly oversimplified way to think about this case is that if an agency uses notice and comment rulemaking or formal rulemaking, although that never happens, or formal adjudication, it's going to get Chevron deference. Otherwise, if the other requirements are met for deferring to the agency, we'll give it Skidmore deference. That is a little oversimplified, but that's sort of a good overview of it. So a couple final questions that sort of get into the nuances there before we'll turn to Brand X. So the IRS is the only agency that administers the tax code. There are a lot of ambiguities in the tax code, right? the IRS interprets those ambiguities through interpretive rules and policy statements all the time. It can do notice and comment rulemaking, but it doesn't use it consistently. And so if the IRS puts out an interpretive rule that interprets an ambiguity in the tax code, should it get Chevron deference or Skidmore deference or no deference at all? What do we think?
So just that I'm understanding it, so they're putting out a an explanation that goes through no formal process. Is it fairly detailed explanation?
Yeah, let's say it's like a 12-page memo that like elaborates on reasoning and cites cases and stuff.
Well, I mean, then I don't know. I think the IRS is extremely nuanced in what they do and probably know it really well. They, wrote the code, and so I think they would likely get Skidmore deference. But I also think that depends a lot on like what the ambiguity is and how they explained it, and it comes down to, I think, a lot of details, which means that it's going to just come down to like that day and how the judges feel, I think.
Well, I mean, so that still means that is still an application of Skidmore deference, right? Like Skidmore deference is not defer to whatever the agency said. It's give it some deference for its persuasive authority. But if it's not persuasive, then like they'd say, no, this is not persuasive, right? So you can apply Skidmore deference and say, no, the agency's wrong. But if they're an expert agency, yeah, they should probably get Skidmore deference at least, right? Because they have a bunch of experience with the tax code. They're definitely experts. Why not Chevron deference?
Because it didn't go through that notice and comment rulemaking process.
Yeah, although Mead itself says that's not the only driver, right? So like in 856, the court says, the overwhelming number of our cases applying Chevron deference have reviewed the fruits of notice and comment rulemaking or formal adjudication. That said, and as significant as notice and comment is in pointing to Chevron authority, the want of that procedure here does not decide the case, for we have sometimes found reasons for Chevron deference even when no such formality was required and none was afforded. The fact that the tariff classification was not a product of such formal process does not alone bar Chevron. And so a more nuanced way to think about Mead is that it modifies Chevron to apply when Congress has delegated authority to the agency generally to make rules carrying the force of law, and the agency has interpreted the statute in the exercise of that authority. So what does it mean for a rule to carry the force of law?
I thought it meant that its intention, or it does bind more than just the parties immediately involved. It has like a broader application, and that the reason this ruling letter didn't have the force of law was because it's really only applicable to the parties that the letter is kind of addressed to or about.
Although you can have like something that only applies to one party that has the force of law, right? Like an order and an adjudication has the force of law, right?
Right, but that went, I guess I thought that was like because it went through the adjudication and like it went through this whole formal process. That's why that has a broader holding than just this letter, which openly states it's only for the parties involved.
Yeah, although I mean, like adjudications, informal adjudications, there's no procedures under the APA, right? Or at least very minimal ones.
Mm-hmm.
And so like due process gets involved and the Organic Act gets involved, but like, I mean, this case involving these letter rulings is like probably the hardest, is this a rule or an adjudication question we've had in the course. I think my instinct is these are probably more adjudications than rules. And so does that mean they have the force of law? And the reason I say they're probably closer to adjudications is because they are specific to the parties and are mostly based on like past facts about the parties specifically, like what are the thing you're importing, and they have kind of effect going forward, but that's only sort of because they keep doing it the same way until they decide otherwise. Like they're very specific to the parties rather than broad social facts. So why did we think that a policy decision or policy rule or an interpretive rule doesn't have force of law?
Was it because it was less democratically accountable because it's made by the agency, maybe instead of not coming from Congress, which I guess in theory is closer to the will of the people, as compared to an agency, which might just be, you know, could be made up of bureaucrats who have been there forever?
I mean, maybe, but like a legislative rule from an agency has force of law, right? Like if the agency says, we classify this chemical in this concentration as a hazardous material, that has force of law. If you have higher concentrations, like you're violating the law. But a policy statement doesn't have force of law in that way because you're not violating anything. All it says is our policy is we intend to exercise discretion in the following ways, but it's when they're exercising that discretion and doing the enforcement action or bringing the lawsuit, they're not saying you're violating the law because you're violating the policy statement. They're saying you're violating the law because you're violating the statute or the other regulation that was adopted through notice and comment or something, right? An interpretive rule, same thing. Like the interpretive rule about what counted as diagnosing an illness in the minors, it wasn't that memo that said, here's what counts as a diagnosis that gave them the ability to do enforcement. It was the original regulation that said you have to report diagnoses that gave them the ability to do the enforcement. That's the thing that you're violating if you don't report it, right? And then this other thing is just like specifying how they're interpreting something. Yeah, Maria.
Isn't it almost like a chicken and egg question though, with like the policy versus a rule? Because isn't like the definition of a rule is an interpretation of a policy, but then a policy is just a general statement that's kind of grounded by the rules?
Yeah, there's definitely a lot of like circularity here, right?
Yeah, so I don't know. It's almost like I would have a hard time distinguishing between how the courts look at a policy statement versus a rule, because really a rule is just
so time out. A policy statement is a rule, right?
Right.
It's just one type of rule.
Okay. Okay, that makes sense, because yeah, I guess I was thinking like if a policy, well, it has the exception though of the notice and comment.
Right. So 553 says rules have to go through notice and comment unless they are national security or good cause or internal operating procedures or policy statements or interpretive rules, right? So the rules that have to go through notice and comment are the ones that we call legislative rules or substantive rules. Those are kind of the default main rules, right? And then the other kinds of rules under 553 are the ones that don't have to go through notice and comment because they don't have force of law.
And that's what they were saying then in this case here about the force of law.
Yeah.
Substantive as opposed to not.
Exactly. That was kind of the punchline, right? Is that like 553, those cases say you don't have to go through notice and comment when your rule doesn't have force of law. And then this case is saying when your rule doesn't have force of law, you don't get Chevron deference. But it's not super clear to me that these decision letters or opinion letters or tariff letters don't have force of law, right? Because they say, if you're importing this thing, you have to pay a 4% tariff. And that's like something that in practice means they have to pay a 4% tariff, right? So what's the argument it doesn't have force of law? Yeah, Derek.
To me, force of law means that it has some sort of like prospective effect. Like you can't take a policy statement, for instance, and go to an enforcement action happening later and be like, look, this was your policy statement. I'm relying on this. Much the same that you can't take, Mead couldn't take their old ruling letters and show up now and say, look, I used to not pay this. I don't have to pay it this time.
Yeah, that's the critical point, right? So if we think back to like the minors and the lung illness diagnosis case, right? The reason it didn't have force of law was if the agency wanted to enforce their power under the statute, they don't say we are enforcing this interpretation rule. They say we are enforcing the requirement that you report diagnoses within 10 days. And we exercising our power to enforce the rule under the statute are determining what counts as a diagnosis. And we gave you notice of that, but we don't have to do that. And so you're not violating the interpretive rule, you're violating the underlying rule, right? Here, when you pay your tariff, or if you refuse to pay your tariff, you're not violating this ruling letter, you're violating the tariff rules, right? But the other side of the coin is exactly what you just said, Derek, right? Like if you have this letter that says your planners are diaries that get a 4% tariff, and next time you try to import them, they say, well, we want a 10% tariff. Can you use that letter as precedent?
I thought I read somewhere that's like for modifications, they had to go through like notice and comment, I think. But that's only notice and comment procedures only when modifying or revoking a prior classification ruling or modifying the treatment accorded to identical transactions. So would they I'll find it. I had it in my notes. I don't know where it's.
Oh,
At the bottom of 857.
Yeah. The new law requires customs to provide notice and comment procedures only when modifying or revoking a prior classification ruling or modifying the treatment accorded to substantially identical transactions. And under its regs, customs sees itself as obliged to provide notice and comment procedures only when changing a practice so as to produce a tariff increase or some other cases, right? Mm-hmm. So if you're importing planners, again, you can take that letter to them and say, aha, I don't have to pay you 10%, I only have to pay you 4%, right? Like it is binding in that sense. So in that sense, it sort of has force of law. Maybe defensive force of law. So this, yet another example where like all of the doctrines in this course are kind of like connecting together again, right? We have the court saying this kind of tariff letter doesn't get deference because it doesn't have force of law, which is the test or the major part of the test for whether a rule has to go through notice and comment in the first place under 553. And so the court says we're going to look to whether there was notice and comment under 553 in large part to tell us if it has force of law. Although here it really does seem like there's at least kind of an argument that it has force of law. In terms of other circumstances where the court might say something other than notice and comment is enough for Chevron deference, there are a few examples, but they're very rare and they're not super persuasive. For the most part, we look to whether there was notice and comment or whether there was like a formal adjudication providing due process that tells us whether Chevron deference is appropriate or not. Final question on this real quick. What about the other side of the coin? Can you think of any circumstances where the court might conclude that Congress didn't intend for an agency to get deference even when it uses notice and comment rulemaking?
maybe when it's just so far removed from the Organic Act that it just almost seems like it's not even connected to the original intent of Congress.
Yeah, so maybe like if they're just doing something that's really wacky, right? There are a couple of examples of this. So sometimes we call this the major questions doctrine, where courts will sometimes deny Chevron deference when agency decisions seem like they are so fundamentally important or so fundamentally distant from the intent of Congress that if this decision is going to be made, it has to be made by Congress. So for instance, in King v. versus Burwell, which is one of the Affordable Care Act cases, the court refused to grant Chevron deference to an IRS regulation interpreting the Affordable Care Act because the question implicated deep economic and political significance. Or there's a case called FDA versus Brown and Williamson Tobacco, where the court said Congress could not have intended to delegate a decision of economic and political significance as whether the FDA can regulate all of tobacco with this general grant of authority to regulate drugs, that there's such a history of tobacco industry in the United States that if the FDA is going to have that authority under Chevron, Congress has to be more explicit.
That's called the major what? Sorry.
Major questions doctrine. But there are counterexamples. So like there's a case involving the FCC in 2013 where the court said that even when the agency is doing something so expansive that it's a fundamental change to the regulatory scheme, it still gets deference. And so it's not super clear whether this is a doctrine that really exists or not, but it seems like there are some cases that are just so significant that the court like steps back a bit from the precipice of like deferring to the agency. Okay, questions on this before we have 2 minutes left, and so probably we're just gonna have to leave Brand X for next time.
So major questions is a lot like the political question doctrine. They're like, this is too big for that person to make the decision. Let's leave it to Congress.
Yeah, that's a good way to think about it. Absolutely. Like, you know, the FDA can't suddenly decide under this authority it's had for 80 years, oh, we're going to now regulate all of tobacco. That's the kind of thing that if they really were going to do that, like Congress has to be involved.
When we were talking about like Chevron and Skidmore, you were saying like if it's not Chevron, it's Skidmore, but then they're like, no, if it's like the agency using its discretion given by Congress, then it's Chevron deference regardless of how formal the procedure.
So so if we have an agency interpreting a statute, it could be Chevron, it could be Skidmore, or it could be neither. It could be just de novo review by the court. And so Chevron is going to be when you've got notice and comment, or you have formal adjudication, or you have formal rulemaking, or you have some other indication that that was Congress's intent, which is principally going to be dependent on whether the rule has the force of law. But if you don't have that, then you have to decide whether they deserve Skidmore deference or not. And that's going to turn on things like, do they have expertise? Did they give this decision a bunch of thought? Is it well-reasoned? Did they write up a good persuasive explanation? And if those things aren't true, then you probably just don't get any deference at all. You probably just get de novo review.
Okay, so Chevron, it's if there's evidence that Congress delegated it.
Yeah.
In the course of law.
Yeah, which is mostly, is there notice and comment rulemaking?
Force of law? Force of law is there notice of comment?
Well, whether Congress intended to delegate it is mostly going to be whether there's notice and comment rulemaking. Force of law and notice and comment rulemaking are mostly going to go go hand in hand. But occasionally there are weird cases where something has force of law, even if it didn't have notice and comment rulemaking, or you can have notice and comment rulemaking without force of law. But for the most part, notice and comment rulemaking equals Chevron equals force of law. Okay, so thank you, Mr. Carroll, Mr. Downing, Ms. Gillis, and Ms. Murphy. I will get the next set of readings up as soon as I can, hopefully later today. And I will see everyone next week or on Friday for office hours if you are around. Have a wonderful weekend. If you have not voted yet, you should do so real soon now. And see you next week.